All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin, and I'm echoing. One of these is not muted. All right, we'll try it again. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say present or here. Raise your hand so I can acknowledge you, and then I'm going to call your case shortly thereafter. Dakota Davis. Ashley Duran. Ashley Renee Duran. Michael Lobb. Michael Edward Lobb. Chester Perry. Kaylee Pettis, or Kaylee Pettis. It's Kaylee, I'm sorry. Rachel Powell. Otis Wheeler. Otis Darrell Wheeler. Joseph Howe. Kenneth Nash. Jamie Johnson. Christopher Hearn. Thanks, sir. Bob Truitt. Billy Otmo. Did I say that correctly, sir? All right, thank you. Billy Fleming. Thank you, sir. I got you. Houston Carpenter. Jackie Elliott. Jackie Lynn Elliott. Chase Enochs. Gary and Hamner. Christopher Nash. John Piercefield. Jason Mullikin. And I have Mr. Dahman is going to be appearing via Zoom, and Mr. Mullikin, I believe, is currently hospitalized, and I've waived his appearance today for purposes of docket call. We'll get an update from Mr. Dahman here in just a moment. Zachary Byrd. Okay, thank you. And I do believe that we verified him in custody on the 22nd. We'll do that again, and then I'll call that case, Mr. Hamilton. Veronica Wortman. Holly Mormon. Holly Mormon. Holly Elise Mormon. She like Chick-fil-A or something, or is she in the jail?
No,
she's in the jail. Oh, okay, she's in custody. Guadalupe Bahina. Gregory Strotter, have verified in Henderson County. So I'll recall that one. Theodore Houston. Jessica Kraft. Just for the record, I think I have this on my docket, so I'm going to note it. Mark Rice, CR 2244. I believe the state filed a motion to dismiss the defendant being deceased. I believe the court has granted that. Josue Rodriguez. Thank you, Ms. Versace. Nicholas Crouch. Zoom at 9:30. And then Mr. Herrera will be at 11:30, so I'll recall those. Is there anyone who's present in the courtroom and I've not called your name and you believe that you're on today's docket? Anyone at all? Okay. All right, counsel, if y'all want to form a line over here, let me know when you're ready. I'll call you up. Mr. Biggs? Who are you ready on?
Mr. Truitt and Mr. Hearn.
Christopher Hearn, CR 22104. You'll come to this middle podium, sir. You may. Ms. Heisel or Mr. Woodwhite, can you draw a sign this waiver of jury trial?
This one, Judge.
All right, Mr. Hearn, if you'll raise your right hand, sir, I'm going to place you under oath. You are Christopher Allen Hearn, is that correct? Mr. Hearn, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Hearn, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? And in this case, you're represented by your attorney, Mr. Kenneth Biggs. Are you pleased with his representation of you? Yes. Feel like you've had enough time to discuss with him the case and have all your legal questions answered? And Mr. Hearn, you've gone over this paperwork today called the pretrial intervention contract. Is that right? And you feel like you understand everything that you've read and signed? And Deputy McLeish, will you kick that air on? Yes. About y'all, warm to y'all? Yes, warm. Mr. Biggs, have you explained the pretrial intervention contract to your client? And do you believe him to be competent today?
I do.
And I see that the pretrial intervention contract is on the charge of aggravated assault with a deadly weapon, which is a second-degree felony offense. And the period of the pretrial intervention is for 1 year. And is there any agreement with, was there any seizure of any weapon, firearm or other?
Your Honor, there were 2 firearms seized in this. The state has spoken with Mr. Biggs, and we are in agreement with Mr. Hearn receiving those guns back after the successful completion of his pretrial intervention contract. There's no disposition in regards to the guns at this time.
Okay. All right, thank you. All right, Mr. Hearn, you've read over this. You've had Mr. Biggs' legal counsel with you to help you understand this pretrial intervention contract. Do you understand that by entering into this contract, the court approves that today you're going to be waiving several important rights? You understand that you're going to be waiving your right to a jury trial? You understand that once you waive that right's not going to be restored to you unless there's very limited circumstances that exist? You understand that when you waive that right to a jury trial, you're waiving your right to confront the state's witnesses and their evidence in front of a jury of your peers? And has anyone threatened, forced, or pressured you to waive your right to a jury trial or give up any other rights that you are giving up in this pretrial intervention contract? You also understand that you would be waiving your right to a speedy trial, and you would also be waiving your right to have your criminal history records expunged with regards to the records of the DA's office and the probation department. You understand that? All right, understanding all of those things. Well, let me ask you one more thing. You understand, Mr. Hearn, that if you go on to this pretrial intervention contract, you're also agreeing to stipulate to the admissibility of evidence of the state. You understand that? You understand that if you violate any of the terms and conditions of this pretrial intervention contract, the state of Texas can ask me to put you back on the docket. We'll have a hearing. And if I find that you violated any of the terms and conditions that you've agreed to, then your case is going to be restored to the docket. And then you can be taken to trial before the court. And you understand that at that trial before the court, you've agreed that the state's going to be able to get certain evidence in that they typically wouldn't be able to get in. Yes, sir. Understanding all of those things, you still wish to go forward. All right, court will Find that Mr. Hearn has been admonished as to his constitutional rights. Court finds that Mr. Hearn has intentionally, knowingly, and voluntarily waived those rights, that he has received the assistance of counsel, and that the waiver of jury trial is joined in by the attorney for the state and the attorney for the defendant. Court will approve Mr. Hearn to be placed in the pretrial intervention program for a period of 12 months. All right, Mr. Hearn, I'm going to have you come and visit with the adult community supervision department here with Officer Burns, and she'll give you more information on what the next step is. Okay. All right. So you'll go ahead and go over here at this time. Bob Truitt.
Sign his conditions of probation. You need that done first.
Has he got them?
He's got them right now.
Okay. No, that's fine. He gets signed as long as he's aware of it. All right, are you Bob Henry Truitt III? Yes, sir. Mr. Truitt, if you'll raise your right hand, we'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, you may put your hand down. Mr. Truitt, have you had enough time to read over your conditions of community supervision? Yes, sir. Okay. All right, Mr. Truitt, are you a United States citizen? Yes, sir. Do you read, write, and speak English? Yes, sir. And have you ever been diagnosed with any type of mental condition? No, sir. In this case, you're represented by your attorney, Mr. Kenneth Biggs. Do you feel like you've had enough time to discuss the case with him and have all of your legal questions answered? Yes, sir. Is there anything about this paperwork that you've read and signed today that you do not understand? No, sir. Mr. Biggs, do you believe Mr. Truitt to be competent today?
I do, Your Honor.
Have you explained all of his legal rights to him?
I have.
You believe he understands them?
I do. I've met with him several times. We've gone over all the details of the charge against him. After some lengthy negotiations and discussions, we arrived at this plea agreement. State for a plea to a lesser charge for a third-degree felony. He's prepared to waive his constitutional rights and plea and ask for the court to follow recommendation.
All right. Does he understand the advantages and disadvantages of a deferred adjudication plea?
He does, Your Honor.
Okay. All right, Mr. Truitt, I see here that you're charged by indictment with a third degree. I'm sorry, that you are charged by indictment. Was it a second degree ag assault?
Yes, Your Honor.
Was. You're charged by indictment with a second degree felony offense of aggravated assault with a deadly weapon, which would carry a range of punishment of 2 to 20 years in prison and an optional fine not to exceed $10,000. I see here, though, that your agreement, as Mr. Biggs has pointed out, is to that of a lesser included offense of deadly conduct, discharge of a firearm, a third degree felony. If you were to be convicted and sentenced by either a court or a jury for this charge, that would carry a range of punishment of not less than 2 years or not more than 10 years and a fine of not more than $10,000. Do you understand that range of punishment? Yes, sir. And I see that your agreement is that you're going to plead guilty to this charge in exchange for the state's recommendation that the court defer a finding of guilt and that the court places you on 5 years community supervision with a fine, court costs, reimbursement fees. Is that your understanding of the plea, Mr. Truitt? Yes, sir. All right, Mr. Truitt, this time I'm going to ask you, how do you plead to the third degree felony offense of deadly conduct, discharge of a firearm? Guilty. Are you pleading guilty to this crime because you are guilty of committing this crime? Yes, sir. Has anyone threatened, forced, pressured you to plead guilty to this charge? No, sir. Our court will accept the defendant's plea of guilt. Mr. Biggs, any objection to the state's evidence? No, Your Honor. State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. In regards to victim notification, the state is in compliance and has received no response.
All right, thank you, Ms. Heisel. Anything further from the defense?
I have the conditions of probation. Do you want?
Thanks, sir. All right, the court's going to review the evidence. Ms. Heisel, you, Mr. Biggs, approach. All right, the court's reviewed the evidence, and I do find that there is sufficient evidence to convict Mr. Truitt of the lesser included third-degree felony offense of deadly conduct, discharge of a firearm. Court will follow the plea agreement in this case. The court hereby defers a finding of guilt, places the defendant on 5 years deferred community supervision. Court will order him to pay a $1,500 fine, $290 court cost, $35 reimbursement fees. Court will also order the seizure of the Davis Industries 38 caliber, 38 special serial number as indicated in the judgment. All right, Mr. Truitt, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with Deputy Police. After that time, then step over here to my right, your left with the probation department. Yes, get my. Mr. Biggs, is that all you have today? Yes, thank you, Mr. Biggs. Appreciate you. Josue Rodriguez, CR 18503 and 504. Show that Mr. Rodriguez is set for docket call today.
Your Honor, we have a resolution on this matter. I have to pick up my daughter at 10 to get her to a doctor's appointment that just came up this morning. We are seeing if we can set it for Thursday for a plea.
Any objections?
No, Your Honor.
All right, court will set Mr. Rodriguez. Will that be for probation or time? Or
It's a
time
probation plea.
Probation. All right, so we'll set Mr. Rodriguez then for Thursday at 9 a.m.
That will work.
All right, Mr. Rodriguez, once you sign and get the yellow copy, you're free to go.
Thank you, Judge.
You're welcome. Cargill, how are you doing?
I'm doing well, Your Honor.
Billy Carl Fleming Jr., CR 2119.
He's gonna need assistance.
Yeah, that's fine. That's fine. It may be easier to go back. Maybe easier to go back and then come across and then come down. Do you want him, or do you want him over on the side here? Okay, yeah. Yeah, come on up. Come on. Slide this out of the way. There you go. You're good right there. You're good right there. All right. So I show that my docket says we're set for a plea, but I also have a note regarding incompetency.
Yes, Your Honor. We originally did a waiver of jury trial sometime back before the beginning of the year. And between that time and the setting, Mr. Fleming got hit by a vehicle. And he was in a coma for quite some time period. And we've had a couple of resets. He's now home recuperating. But in speaking with him and working with him, his memory lapse is very bad. He doesn't remember who I am each time and some communication issues. And I asked for an examination for his competency to see if we can go further on. And I've discussed the same with the state, and I believe they're unopposed.
Okay. Ms. Heisler, we'll approach you. All right, the court is going to grant the defense's motion for evaluation. And the court hereby appoints Dr. Timothy Ingram to perform this evaluation. The court's going to sign the order. Oh, no, this is not correct. This is all right, so Mr. Fleming, the court is going to have a doctor come and interview you, ask you some questions, do an evaluation of you. I'm sure you're probably tired of seeing doctors and listening. I understand. It's a terrible ordeal that you're going through. I'm sorry you're going through that. But this doctor he's a good doctor, and he's not going to poke and prod. He's just going to ask questions and get to know you a little bit better. Okay, so we're going to send that information to your attorney, Mr. Cargill, and he's going to get a hold of your family, and we're going to get this going, and we'll get it sorted out. Okay. All right. So let's reset this for a status on the evaluation. Mr. Cargill, do you have your calendar with you?
No, sir. Sorry.
It's okay. About 50 to 60 days, we could do June 14th or 16th.
You know, I can tell you anything from June the 12th through July 4th, I'm unavailable. I have a trial and then a vacation letter.
You said June 12th through July 4th?
Yes, Your Honor. That July 4th week I'm available, but not the actual 4th or 5th.
About maybe we tried a little bit earlier, June 2nd.
Oh, I'm available then.
If not then you have July 5th or July 7th. Let's see. I want to make sure I give Dr. Ingram enough time. Date is the 6th. 4 weeks. All right, let's set it for June 2nd. We'll set it for June 2nd. We'll set it at 9 a.m. Here, that's okay. I don't need to sign. If everyone signed there with the new date, you just take that off, give him the yellow copy, and you can leave the white copy right there.
Thank you. Maybe excuse you.
Thank you, sir. They're in. Is there anyone available from Henderson County Jail? Mr. Crouch? I'm going to leave them in and then we'll work them in. Mr. Gimbel, are you ready?
Yes, Your Honor. Have Mr. Zachary Byrd. He has 2 cases set on the docket today, and just recently become aware that he is in custody in Rockwall County. And if we could request a reset, I could verify his status and find out if and when he anticipates being released on Rockwall.
All right, this is cause number CR 2148, CR 21108, State versus Zachary Dane Byrd. Court has verified that he is showing to be in custody in Rockwall County on their on their official web records. All right, and the court's going to find that Mr. Byrd's bail in this case is insufficient. The court's going to increase that bail and issue a warrant for Mr. Byrd's arrest.
Oh, yeah, there it is.
We'll reset Mr. Byrd for status of his
Thank you.
custody.
Thank you.
Mr. Gimbel, are you available? You available on June 2nd?
Yes, Your Honor.
All right, let's set Mr. Byrd for status and docket call June 2nd. And that'll be at 1:30. We'll put him on the afternoon docket. So I don't know if you heard me when we went back over to talk to Ms. Heisel, but I'm going to find his bail to be insufficient. And then you can find a motion, you can file a motion to reinstate bail if you believe it's appropriate.
Judge, I will note for the court's records, we appreciate that. It appears as though Rockwell is putting him on our charges as well, so he may already have that. But if the court would verify and then do it. That's
They're holding him on our charge. I mean, they've executed a warrant on it.
Shows
It
on there.
shows that they are, whether that's in fact the case or not, we're not sure, but that's just what Rockwell County's records are showing.
Okay.
So we will look into that and we'll discuss with the court as well, make sure Mr. Gimbel's aware.
All right. So June 2nd at 1:30. Is that all you have, Mr. Gimbel?
That is all I have today, Your Honor. May I be excused?
Yes. Thank you, sir. I'm bouncing between Tyra, Tira. I'm gonna go with Tyra.
Tyra.
That's right. The more you hear, the easier it'll get for me.
It's Jamie Johnson, Judge. It's 21. Oh,
They got your name backwards. They got you listed first name first instead of last name. So we'll do that. Thank you, sir. This is CR 21295, State versus Jamie Wayne Johnson.
Judge, she's present. We're here for pretrial. There's some discovery that we were waiting on, speaking with the state. We think that those photos are now present. So I was going to go pick those up today. I also have an agreed motion that should be in the e-filing to modify the conditions of my client's bond where she can move back to Van Zant County.
Yes, is Ms. Johnson living in Rockwall now?
Correct. And she'd like to move back to her residence and outside of Wills Point. And I believe I included that address in the proposed order. And I've also discussed with the state this morning, there's also a CPS case. The conditions of her bond involves any family of victims. In this case, the victim was her husband, and her child is involved in the CPS case. And so I've recently gotten into that, but because of the conditions of bond, the CPS court hasn't allowed her any contact with her son during the pendency of this case. And I would ask the court to modify the conditions of bond in this case to allow the CPS court to address whatever contact she may have with her son, if the court is okay with that.
State.
The state has no objection to lifting the bond conditions and letting CPS decide what's appropriate depending on where she stands in her services with them.
Is it, no objection to lifting or modifying the condition to allow contact with the son or all family members?
With specifically Braden, the son.
All right, the court will, and you, as the state, have also agreed to the motion to allow Ms. Johnson to move back to Van Zant County.
Yes, Your Honor.
And Ms. Curry's signature should be on that order in the e-file.
All right, the court will go and the court will grant the order, the agreed order on the agreed motion regarding her residency, and the court will modify the conditions of pretrial release to allow Ms. Johnson to have communication with Braden. Is his last name also Johnson?
Yes.
It's Dickinson.
Dickinson.
Braden Dickinson. All right, so it'll take me a little while to get that paperwork done, but I'll get that done today. Any other issues on pretrial that we need to set off for?
No, Judge, I would just like one reset to go over those photos and make sure we have everything.
Any objection from the state?
No, Your Honor.
Be available on June 2nd?
June 2nd, I believe that would be fine. Yes, Your Honor, I can be there.
All right, we'll set Ms. Johnson then for pretrial on June 2nd. That'll be at 9 a.m. And I'll attend to those orders on break or at the conclusion of the docket.
Thank you, Judge.
Mr. Adams, I'm going to work you in next. I'm sorry, I've got a Zoom plea with Henderson County. Mr. Crouch. Mr. Tyra, is that all you have today?
That's all I have.
All right, Mr. Crouch, can you see and hear me okay?
Yes, sir.
All right, let me see, I'm not hearing you, but that might not be your fault. So,
Yes, sir. I can hear you loud and clear.
Mr. Crouch, give me just one moment. I've got some audio issues over here. I'm going to fix these real quick, hopefully.
Yes, sir.
Mr. Crouch, can you say your name for me?
Nicholas Scott Crouch.
Yeah, I'm sorry, Mr. Gotch, I can't hear you at all. I don't believe it's your problem. I believe it's my problem here. I'll give you a second.
Nicholas Scott Crouch.
All right, Mr. Crouch, say your name for me now.
Nicholas Scott Crouch.
All right, perfect. Got you now. Sorry about that.
It's okay.
All right. All right, this is cause number CR 2210 and CR 2211, CR 2212, CR 2213, State of Texas versus Nicholas Scott Crouch. Mr. Crouch, if you can raise your right hand for me, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. You are Nicholas Scott Crouch, is that correct?
Yes.
And Mr. Crouch, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
Yes.
What have you been diagnosed with?
Depression.
Are you currently undergoing treatment or are you on any type of medication for depression?
No, sir.
Do you feel like today you have rational thought and understanding so that you understand the proceedings that are going on against you here today?
Yes, sir.
All right. In this case, you are represented by your attorney, Mr. Mitch Adams. Are you pleased with Mr. Adams' representation of you?
Yes, sir.
Feel like you've had enough time to discuss all of your cases with him and have all of your legal questions answered?
Yes, sir.
Is there anything about any of this paperwork that you have read and signed that you do not understand?
No, sir.
Can you see Mr. Adams? Okay, Mr. Adams, raise your hand. I want to make sure. Can you see Mr. Adams there?
Yes, sir.
Okay. And Mr. Adams, do you believe that Mr. Crouch is competent today?
Your Honor, Mr. Crouch and I have visited on numerous occasions regarding his cases. We've discussed it thoroughly. He understands what it is that he's charged with, who the relevant actors and players are. Based on my interactions with Mr. Crouch and my conversations with him, I've come to the conclusion that he is legally, mentally competent.
All right. And you have also explained his legal rights to him, and do you believe he understands those?
Your Honor, he understands the rights afforded to him under the U.S. Constitution and state constitution as a criminal defendant, and he understands the consequences of what he's doing here today vis-a-vis those rights.
All right, Mr. Crouch, I see here that you have been charged by indictment with, you've been charged by indictment 4 times with the same charge, that being a burglary of a habitation in each one of these cases. And each one of these cases being the same charge is a second-degree felony. And a second-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, and also a fine in each case not to exceed $10,000. Do you understand the range of punishment on each one of these charges?
Yes, sir.
All right. And I see here that you want to enter into a plea agreement with the state in these cases, and it appears that you're going to plead guilty and ask the court to accept the agreed sentence of 10 years confinement in TDC.
Yes, sir.
With no fines, but you would be paying court costs and restitution in each case. And it appears that the state would be dismissing some of your unindicted and indicted cases along with this charge. It looks like an evading arrest or detention with previous conviction. That's DA 2021-1127. And then each sentence is to run concurrent with the other cases. Is that your understanding of the plea agreement, Mr. Crouch?
Yes, sir.
And the court would also be giving you the time credit that you've earned for sitting in jail prior to this plea in the amount of 217 days. Do you believe that that is the actual time credit that you're entitled to?
Yes, sir.
Okay. All right. So, Mr. Crouch, understanding the plea agreement, understanding the range of punishment, do you still wish to go forward with the plea in each one of these cases?
Yes, sir.
All right. So, Mr. Crouch, in cause number CR 2210, how do you plead to the charge of burglary of habitation?
Guilty.
CR 2211, how do you plead to the charge of burglary of a habitation?
Guilty, sir.
CR 2212, how do you plead to the charge of burglary of habitation?
Guilty, sir.
And CR 2213, how do you plead to the charge of burglary of a habitation?
Guilty, sir.
All right. And Mr. Crouch, are you pleading guilty to each one of these charges because you are guilty of committing each of these crimes?
True. Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to any of these 4 charges?
No, sir.
All right. Court will accept Mr. Crouch's plea of guilt on each charge. Mr. Adams, any objection to the state's evidence as offered in each case?
No objection is marked and offered, Your Honor. I would note for the court's information in each indictment, there's an enhancement paragraph.
There's no plea of true to the enhancement. Is that correct?
There is plea of true.
It's not reflected on any of these judgments.
Good. Well,
State would agree to proceed waiving the enhancement paragraphs. The prescribed, the agreed upon sentence would fit within
objection to that.
Okay. All right, the court will accept Mr. Crouch's plea of guilt at this time. The court will take judicial notice of his judicial confession. There being no objection to offered evidence, the state's one is admitted in each case respectively. Anything further from the state?
Your Honor, just that the state is in compliance with victim notification, and there is no response from either of the victims in these multiple cases.
All right, thank you, Ms. Heisel. All right, anything further from the defense?
No, Your Honor, we arrest the clause.
All right, court's going to review the evidence.
And for the record, I just want to tell the victims that I'm sorry and I apologize.
Thank you, Mr. Crouch.
Yes, sir.
All right, the court has reviewed the evidence in each case. The court finds that there is sufficient evidence to convict Mr. Crouch of the offenses. The court will follow the plea agreement in each case. The court hereby convicts Nicholas Scott Crouch of burglary of a habitation in CR 2210, CR 2211, CR 2212, and CR 2213. The court assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division in each case respectively. Court orders him to pay court costs of $290 in each case, $20 reimbursement fees in each case respectively, and the court awards him 217 days credit for the time that he has spent in jail on this cause in each case. And the court also dismisses under section 1245 cause number DA 2021-1127, evading arrest or detention with previous conviction. The court orders each sentence to run concurrently with the other three charges. Mr. Crouch, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. And I believe that Henderson County has already fingerprinted you or will be fingerprinting you on these judgments. I just ask that you cooperate with them when they do that, and they're going to send that back to us for our records, okay?
Yes, sir.
All right. Anything further from the state? From the defense?
Nothing further.
Thank you, Mr. Crouch. And if you will, just extend my gratitude to the Henderson County detention officers for making you available this morning so that we could get this done via Zoom. Okay.
Yes, sir. God bless you. Thank you.
Good luck, Mr. Crouch.
All right. And I believe that the state's going to need to sign these. This one wasn't signed.
Yeah, I don't think they are. Any of them are, Judge.
Just leave these for me. Since he's not here, there's no super rush. Mr. Schmidt, are you ready? You just have Jessica Kraft?
Yes, sir.
Jessica Kraft, CR 1847. And Ms. Kraft is set today on a motion to revoke.
That's correct, Judge. We're still negotiating with the state as for an additional setting on this craft ATA.
All right, court will set Ms. Kraft, I'm going to put her on the contested docket on May 26th. That'll be at 9 a.m.
I'd left my calendar. I think I'm in, I have a vacation letter on that May 26th docket, but I'm not 100% sure. I left my phone.
Can you do me a favor? Will you look to see if Richard Schmidt has a vacation letter? Has any dates blocked off for 6th? Thought that he may have, but wasn't sure. Okay, thanks. All right, yeah, you did have one for that. All right, so let's, are you available May 12th?
Set Tuesday and Thursday.
That's a Thursday. Wouldn't be a contested date though.
You're on the 10th,
10,
sir.
we're at max capacity on that day.
You're also June 16th.
But we'll have to set her June 28th for the contested docket.
June 28th.
Ms. Kraft, you understand that you're still on community supervision.
Yes, sir.
So I've got a note here that says you're not going to counseling.
I have.
No, it's okay. That's okay. I'm just telling you what I know and what I have. So you're going to want to discuss that with Mr. Schmidt because you can make his job more difficult because I've reset your case to June. And if you keep on violating by not following the conditions, you're going to make his job harder
Yes,
to make you happy.
Yes, sir.
Understand? All right. So you need to check in with your probation officer today.
I am.
And I'll see you back on June 28th. Sign that yellow copy. You're free to go. Is that all you have, Mr. Schmidt? Hawkins, you ready? Veronica Wortman, CR 2319. All right. And is she ready for arraignment?
She is, Your Honor.
Go ahead.
Can you state your name, please?
Veronica Wortman.
And then you understand what your charges are, is that true?
Yes, sir.
Okay, and at this time, you plead not guilty,
Yes, sir. It's true.
and you're aware that I'm your attorney representing, is that true?
Yes.
All right. And does she understand what she's charged with and the range of punishment?
She does, Your Honor.
Okay. All right, court will find that Ms. Wortman has waived the formal requirements of arraignment. Court will enter her plea of not guilty into the record, and we will set her for pretrial hearing. Be available on May 24th or June 2nd.
Judge, if we do May 24th, I have a setting over here already on that day, so that'd be fine.
All right, we'll set Ms. Wortman then for pretrial on May 24th at 9 a.m. So Ms. Wortman, once you sign and get the yellow copy, you're free to go. Yes, thank you, Mr. Hawkins. Guadalupe Bahina. This is CR 21160. we're set for pretrial today, Mr. Jarvis.
Here we are, Judge. Mr. Bell's on that case with me.
Judge, I think there's some issues with video. I think we'll get those hopefully corrected this time. Maybe one more pre-trial, and then we ought to be able to resolve the case.
Remind me the relationship here on the representation of Ms. Bahina between
Counsel.
Just co-counsel, Judge.
co-counsels, retained and
Both retained.
both retained. Okay. All right. Any objection from the state on Mr. Knoll's request? I'm sorry, Mr. Knoll, I didn't have you on the docket. It
That's okay.
just shows one attorney, so. All right, court will reset Ms. Bahina for an additional pretrial setting. May 24th or June 2nd.
June 2nd.
June 2nd, all right. Court sets her for pretrial June 2nd at 9 a.m. Ms. Bahina, once you sign and get the yellow copy, you're free to go.
Thank you, Judge.
You're welcome.
May I be excused?
Yes, sir. Are you ready on Mr. Houston?
Judge, yes, Mr. Houston is way in the back. There'd been some medical records, which
Do you want me to call him up?
yes,
Okay.
well, or he can, it's okay if he stays there. He is here.
No, are you going to make an announcement? Are we going to do something on the case? Are you going to make an announcement?
My announcement on his case is I've provided the state with some additional medical records. It's my understanding on the co-defendant, there was an issue that's been cleared, and there may be a new and different offer coming down the road, hopefully by June 2nd. That's good with the court.
Mr. Houston, if you'll come forward, please. This is cause number CR 21264, State versus Theodore Elias Houston. All right, so I heard all of that, but so what are you telling me, that you want to reset on docket call?
Correct, Judge.
State?
Your Honor, state's in agreement. We do need to review these records. There has also been disposition in the CPS case that I believe will affect the outcome of this as well. So we're in agreement with a reset to get all of that on the same page.
Judge, that was a relinquishment with the CPS.
Okay, court will reset Mr. Houston, May 24th or June 2nd, Mr. Knoll?
June 2, Judge,
June 2nd.
please.
All right, court resets Mr. Houston for additional docket call on June 2nd at 9 a.m. Mr. Houston, once you sign and get the yellow copy, so you're free to go.
Judge, I think I have one more on the docket. That's Mr. Crane, who's in Wood County.
Crane?
Robert Crane.
Oh, sorry.
Oh, Lord.
Well, if he's in Wood County, is he planning on zooming in from Wood County?
They usually set that up.
Okay.
I'm not sure obviously, but today's my phone. They have.
Give me a second. I'll work through some others. If you'll stick around, we'll look at it.
Okay.
All right, thank you, Mr. Houston. You can step aside. Mr. Bingham, you ready, sir?
I am, Judge.
Billy Joe Otto, CR 2241. All right, Mr. Otto is set for pretrial today.
That's it, Judge. Yes, sir. And I can go through, we filed the motion, we filed a number of motions. I don't know what order the court wants to go through them, or if the court wants to go through
Are
them.
they motions that aren't covered by the standing orders?
I think they would be, and I didn't know what the court, we have like some to carry, the 702 and 705 to carry. Other than that, I think they're pretty much covered. We had filed a motion to suppress. We're not urging it now. It was an issue that we had a video, audio and video with no audio, but there is no audio, and I don't think that offered anyway. It was just the defendant claimed his fifth, so we don't have an issue with that. I think they pretty much provided discovery, but I don't think there's anything that we're aware of that they haven't provided. And I'm in contact with Mrs. Curry, and they're in the DA's office. I think they provided everything, so we really don't have too much.
So no contested motions at this time. And you believe the rest of your motions may be covered by the standing order, or they will just carry it to trial?
That's fine, Judge. I think that's all true, and I think they provided us everything they have. And other than that, we'll subpoena. So.
Okay. All right, then there being no contested pretrial motions, we'll set this for docket call. Be available May 24th or June 2nd?
I am June 2nd. That's good, Judge.
June 2nd?
Yes, sir.
All right, Mr. Otmo, court resets you for docket call on June 2nd. That will be at 9 a.m. I do show that I have a note that there's an issue with the bond supervision fees. And I believe the amount is 280, but that may be high. That may be, I don't know if that's all bond supervision. I think that's attorney fees that would be owed if Mr. Bingham is retained. So what I'm going to ask you to do, Mr. Otmo, is once you sign and get the yellow copy, you'll come back here and check with Officer Burns here. We need to get any delinquencies that you have on your bond supervision taken care of. Okay. And then Mr. Bingham, I don't know if you have a copy of this. I apologize. I'll tell you what.
No, he's down the road. He's in Holly Tree and I'm behind Hobbies. But we'll send him everything on the top. Okay. Thank you very much, Judge. You're very welcome. Mr.
Weiner, you ready? Yes, sir. Holly Mormon.
Regretfully, she is in the Smith County Jail. I'd be under Mike's name, Judge. Yeah.
Yes, it is. Thank you. All right. Yeah, we thought maybe Patty thought she was at Chick-fil-A earlier today. She said something like that.
I appreciate the wishful thinking, Patty.
All right, this is CR 16-139, State versus Holly Elise Mormon. And let's see, I believe that Ms. Abraham said that she had confirmed that she is in the Smith County Jail also. All right, let's set this for a status on custody. Do you have any information on why she's there, how long she anticipated to be there?
It would be her second motion to revoke, so I anticipate she's going to be there for a while. And I guess I just asked the court to forfeit her bond so she could at least start earning time here based on her positioning in Smith County. Typically don't do that, but I just think that's just in the best interest of my client.
Is she facing a motion to adjudicate or revoke their
Second one, Judge, yeah.
Okay. All right, let's set her out. Set her out to be available either June 2nd, 14th, or 16th. We'll just do a status on.
Those are the 2 weeks.
What about June 28th?
That will work.
Okay, we'll put her. That's the contested docket anyway. So we'll put her on the 1:30 that afternoon.
And do I just go ahead and fill out a recess slip without her signature, obviously?
Yeah, if you could just put that she's in custody in Smith County, and that'll work for me. And then I'll do. Can you give me an order finding her? I'll tell you what. I've got a pre-filled.
Okay.
I'll just fill that out. We're going to forfeit her bond.
That's great.
Violation of conditions of pre-trial release or at defendant's request.
Yes.
Okay. I'll get that done.
And after that, maybe excused.
Yes, sir.
All right, I'll see you 1:30.
Yeah, I just want to ask for it so she can start getting credit. Yeah. All right, thank you. Mr. Adams, are you ready? Are you ready?
Both Mr. Nash and Mr. Howe.
Joseph Howe, CR 2226. Mr. Howe is set for pretrial today.
Correct, Your Honor. We don't have any pretrial issues to take up with the court this morning. The state has extended a plea offer in this case related to Mr. Howe. We've talked about it. He's advised me that he wishes to accept it. So I think what we need to do at this point is set him for a plea hearing.
I have some availability on May 12th. Do you know if you'll be here May 12th?
I have a pretrial hearing in Hopkins County. So
Is it going to be for probation or fine?
it's going to be for probation.
Probation? So you'll be in Hopkins County, is that at 9 a.m.?
It is.
Do you expect that to be a long hearing?
I expect it to be a longer drive.
Long drive. So that's an hour here. I'm gonna do May 24th. Is that better for you?
I have one setting on your docket in the afternoon. I don't have a morning docket that day. I hate to be persnickety, but if I can only spend half the day here on the 24th, that would allow me to spend a little more time in the office being productive. Not that I'm not productive over here, of course.
Otherwise, it's going to put him out into June. I don't want to go that far if he's. What if we did? What if we set him at like 11 or 11:30 on the 24th? They give you time to make your appearance in Hopkins. It's about an hour down.
On the 12th?
I'm sorry, 12th.
12th, that'll
Be okay.
that'll be reasonable.
Okay. All right, let's do that then. We'll set him at 11 on May 12th. All right, Mr. Howe, once you sign and get the yellow copy, you're free to go. We'll see you back on May 12th at 11 a.m. Kenneth Nash, CR 2271. Mr. Nash is set for arraignment.
Correct, Your Honor. Ready to proceed?
Go ahead, I'm sorry.
This is Mitch Adams on behalf of Mr. Nash. Mr. Nash and I have reviewed the indictment in this case. He advises me that he understands the charge made against him in that indictment, that his name is properly set forth and spelled in the indictment. At this time, we would waive the formal reading of the indictment, enter a plea of not guilty, and ask that the court set us for a pretrial hearing.
All right, court will find Mr. Nash has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. We will set this matter for a pretrial hearing. Available June 2nd.
Yes, sir.
All right, Mr. Nash, you're reset for June 2nd. Once you sign and get the yellow copy, you're free to go. So, thank you. Is that all you have on the morning docket?
That's all I have for the morning docket, Your Honor. May I be excused till later today?
Yes, sir. Mr. Manning, are you ready?
Ready on Miss Kaylee Pettis, CR 2274.
Kaylee Pettis, CR 2274. Ms. Pettis is set for arraignment today.
Yes, Judge. I have spoken to Ms. Pettis. I have showed her a copy of the indictment. She understands the charge against her, the range of punishment. Her name is spelled correctly, and at this time she's pleading not guilty.
All right, court will find Ms. Pettis has waived the formal requirements of arraignment. Court will set, court will also enter a plea of not guilty into the record and will set her for pretrial hearing. Available on June 2nd.
June 2nd will work great, Judge.
You're a Thursday guy, is that correct?
That's correct.
I'm gonna learn this. All right, Ms. Pettis, court is gonna set you for pretrial on June 2nd at 9 a.m. After you sign and get the yellow copy, then I need you to report over here to Officer Burns. I'm gonna have you sign conditions of pretrial release. These are gonna be conditions that you're gonna have to comply with so that you can stay out on bail during the time that your case is pending, okay?
Yes, sir.
Mr. Manning, you want to go ahead? We'll make an announcement on Mr. Strotter. I understand he's in Henderson County Jail.
Yes, sir.
All right, it's cause number CR 2412, State versus Gregory Strotter. Do you have any information about how long he may be in Henderson County, what he's there for?
Judge, I do know that he is there on some pending charges that were previous to his Van Zandt County cases. They're of a higher nature degree, and so plan was for him to go down there, take care of his business down there, and we'll run whatever we have here, CC with that.
All right. Do you know if Mr. Strotter is wanting his personal bonds still being intact here?
I believe he had been given PR bond. That's correct, Judge. If we can just have a hold on him, like I said, I think whatever agreement we have is going to run CC with.
So you may find this bond insufficient, so he can start getting time. All right, court will find Mr. Strotter's personal bond to be insufficient. Court will set surety or cash bail in this matter. The court will reset Mr. Strotter for status of custody June 2nd at 1:30. You may. I'm texting you as we speak.
Judge, I also have waivers of arraignment for two of my clients that are in jail that were appointed earlier this week, just so we don't have to
Are they
hold
on
up.
the docket this afternoon?
They are, Judge.
Okay.
And I believe the reset date for those was at June 2nd as well.
Who are they?
Jose Romero, CR 2237.
Okay.
And Gerald
Foylan.
Boylan. And Judge, we will be needing on Mr. may have Romero interpreter on his case. So I was in committee.
Use an interpreter during the extradition. Set that up for June 2nd. I sent you a text. Okay. Oh, no, I'm sorry. I was talking. I sent you a text to Strotter, Mr. Fleming's client.
Judge, I can't,
Can't hear me?
yes, I can, Judge. How are you today?
I'm doing great. Sorry, I was on mute when I was talking to you.
Oh, that's fine.
It's a cruel trick we play sometimes. All right, this is cause number CR 2404, State versus Jason Lee Mullikin. Court has confirmed that Mr. Mullikin is hospitalized in Baylor, Dallas. We are set for docket call today. Mr. Dahman has provided that information to the court. The court has waived Mr. Mullikin's presence at the required presence at the docket call today. Any announcements from you, Mr. Dahman, regarding his status?
Not at this time, Your Honor. I've had plenty of conversations with him in which he's indicated to me that he wants this to go to trial. However, given his current health situation, I would like to withhold any sort of announcement at this time. There could possibly be a concession on the part of the state that might change things. And I'm just, without knowing more about his health, I'm reluctant to make any announcement.
All right, I think probably the wise thing to do here is just reset this for an additional docket call, and we'll set it out another 30 days and get a status on him at that time, and then make our decision as to whether we set him for trial or something else. Okay. All right, Court, are you available on June 2nd, Mr. Dahman?
Let me take a look real quick, Your Honor. You said June 2nd?
Yes, sir. It's a Thursday.
Hold on. June. Yes, Your Honor, I am.
All right, we'll set Mr. Mullikin then for docket call on June 2nd at 9 a.m. And what I'm gonna have to do is rely on you to give him notice, since I've waived his appearance here today.
Absolutely.
I'm just gonna get that notice through you here in court, okay?
Excellent. Thank you, Your Honor.
All right, I'm sorry for the delay this morning. We had some technical issues and some other things, so sorry it took so long to get to you.
No worries at all. Thank you for your for accommodating him and me.
Yeah, you're very welcome. All right, have a good day.
You too.
Mr. Davis, Dakota Davis, I want you to come back here and report to Officer Waddell. He's going to administer a UA test on you today. And then after that, after I get the results, then we'll have a hearing on your sanctions court hearing. Rachel Powell. Ms. Powell, I want you to come forward too, and I'm going to conduct a UA evaluation. Come on forward. And then after I get the results of that, we're going to have a hearing on your sanction court. Is Ashley Duran here? Chester Lee Perry, CR 2273. All right, Mr. Perry, this is cause number CR 2273. Appears that you've been charged with possession of a controlled substance. I have a note on my docket that you've indicated that you are hiring Mr. Jeff White to be your attorney in this matter. Is that correct?
Yes, sir.
Have you hired him yet?
Yes, sir. I haven't spoke with him yet. We hadn't met yet.
So have you hired him or not hired him?
Yes, I've hired him. I see him May 3rd.
Okay, so but you haven't hired him because you haven't met him and you haven't paid him, right?
I mean, I've met him, I paid him, but I haven't met him to go over the case yet.
So is he going to be here today?
No, sir. He had a prior commitment.
No,
He
oh, he
was
was.
here, but he left. He indicated.
Spoke to him, he told me that it wouldn't be necessary that he'd be here with me today. I meet him May the 3rd. I saw him when he walked in.
You've already met him. You've already met with him and you've paid him.
My sister paid him. I have not met with him
Do
yet.
you know that for a fact?
Yes, sir.
I didn't see Mr. White. So,
I didn't get with him until last Friday.
well, what I want you to do is step out into the hall. He might not have known that you were here today. I'm not
Okay.
sure. So I want you to step out in the hall, give him a call. Do you have his number?
Yeah.
Okay, give him a call, tell him you're set for arraignment, and ask him if he can come over and we can arraign you and get you scheduled and get you on your way.
Okay, thank
Okay.
you.
Michael Edward Law, CR 2269. All right, Mr. Lobb, you had requested a court-appointed attorney. The court's reviewed your information. The court has found you to be indigent at this time. The court has appointed Honorable Jonathan Manning here to represent you, and you are set for arraignment today. Mr. Manning, have you had a chance to review the indictment with Mr. Lobb?
I have not yet.
You just received that. Do you want me to recall the case and give you time, or do you want me to display it?
Judge, I have it with me. You just.
Yes, sir, no problem. back on the record with CR 2269, Michael Edward Law. We're set for arraignment. Go ahead, Mr.
Judge, Mr. Lobb's name is spelled correctly. He understands the charge against him. And he understands the range of punishment as well as the enhancements that have been placed on him. And at this time, he's pleading not guilty.
All right, the court will find that Mr. Lobb has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record. The court will set him for pretrial hearing on June 2nd. And that will be at 9 a.m. Mr. Manning, that's going to be set at 1:30. Sorry, I said 9.
Trial.
All right, Mr. Lobb, your bondsman has filed a request to go off of your bond, so a warrant has been issued. So I'm going to take you into custody at this time.
He said that I was in contact with him, Your Honor. He said he would leave it up to you.
I know, and I've made my decision. Show up late to court. He's asked to go off your bond. You're not paying on your old cases.
I've been unemployed, Your Honor.
I understand. Well, is that unemployed is the reason you can't come to court on time?
No, sir.
Okay, I called your name at 9 o'clock. You weren't here.
I got a 81 model pickup Dodge that doesn't run worth the crap. It's been in the shop. I can show receipts. I
understand. We'll take you into custody at this time.
Please.
I've already made my decision.
Child support. Okay, I got some things back here.
You can work it out with Mr. Nicholas. We'll put you back on.
Sir?
You can work it out with your bondsman, Mr. Nicholas.
Have you been in contact with him
He's been in contact with my office
since I got here?
since you got here. Mr. Perry, did you get a hold of Mr. White?
My sister didn't get over to Friday. She told me that I was his client, and she would text him, try to get him to come back over here.
Is that the good news or the bad news?
The bad news is my sister didn't get over there Friday.
Okay, and that's why I asked, did she pay him?
The good news was that she goes, as far as it goes, you are a client.
That's what Mr. White's office did?
That she would contact him and try to get him to get back over here.
Okay, so he's maybe on the way?
Well, I hope he is. I don't know if she said she texted him and said he said he was kind of out of pocket. But she didn't know where he went when he left here.
Okay, all right, we'll give it a few more minutes then. All right, Miss Powell, this will be off the record. So, all right, Miss Powell, come on, right over here. All right, Ms. Powell, we were set to have a sanctions status hearing on some issues. I show that you're continuing to miss for your evaluations as a condition of your community supervision. We were going to talk about that today. However, the officers have told me that you have tested positive on the UA. So we're going to send that off for confirmation. So I'm going to you're going to go home today. Next time you come to court, not likely. They come back and say that you're positive, we're going to ask for the lab to confirm that. If we find that you're using methamphetamine or anything else, then you're going to have other issues to face. So you're free to go right now, and I'm going to have you come back on. You want me to reschedule this? But how long does it take the lab to? couple weeks. May 24th. So I'm gonna have you come back on May 24th at 9 a.m. Okay, so you're gonna sign this form right here. You're gonna get a yellow copy. Is Otis Wheeler here? Otis Wheeler? All right, this is cause number CR 2329. This is a sanctions court hearing on Dakota Davis. Mr. Davis, a couple of things. One, the probation department is wanting to amend your community supervision conditions to have you do substance abuse evaluation with Mr. Chuck Jakes. Do you have any opposition to that? All right, court's going to amend your conditions of community supervision. You have to complete this evaluation within 90 days from this order. So whenever Mr. Jakes gets you set up, then you need to do that. Okay. There's a couple of other things that concern me about what's going on in your life right now. Just admitting to using alcohol, fights, being around people that smoke marijuana. All of these things are going to put you in prison. So I'm just going to tell you. So I read in here that you have a daughter? Yes, sir. You have more than one? You have kids? What do you have? Just one? How old is she?
She's 3.
She's 3.
And recently I've stopped hanging out with everybody that does all that. I don't really go out anymore. I stay by myself.
To me, if you kept that up, and I'm glad if that's true what you're telling me, I have no other reason but to take you at your word. But if that's not true, I can just tell you that the train's coming. And it's going to leave. Next stop will be prison. 3-year-old daughter will grow a lot. As 3 years old, they learn a lot. They grow a lot in a very short amount of time. And it would be very sad to have you locked up in prison because alcohol, or you hang around people who smoke pot, or you get fight with your ex-wife or wife, whatever she is, or whatever she is. You get fights with her boyfriend and all these things. If you allow all of those things and other people to control your life, then they're gonna put you where they want you, and they may want you in prison. So I doubt your little girl wants you in prison. You're gonna miss a whole lot of her life if you're locked up for up to 2 years in prison, day for day, no parole, no good time, no. I serve one, I get credit for one. I serve half my time, get out. It's day for day. So if you get a sentence here for 24 months, which is what you're looking at, that's the maximum. Then you go in and come out, and your little girl's 5 years old. How sad would that be? How sad? It'd be really sad.
She's moving.
Yeah. She might not even know you. If you're gone for 2 years, how sad would it be for her to think that the boyfriend that you don't like and you're fighting with is her dad?
It'd kill me.
Yeah, it would. It would kill me too if I were in your situation. So why don't you use that as your motivation to comply with all your conditions of probation and do what these officers are telling you to do, because they're trying to help you. They're trying to get you to a position where you can complete all of this and get the government out of your life, and then you go be a regular citizen, dad, son, father, whatever you want to be, right? But it's my job to warn you that if you get any more of these things, these officers are going to have no choice but to come in and file a motion to revoke. And then I've got to apply the law to you just like I do to everyone else. It's got to be consistent. If you're going to drink, you're going to smoke marijuana, you're going to be around marijuana, you're going to fight, you're going to whatever, continue this, I'm going to have no choice but to put you in prison. It's going to be sad for you. It's going to be sad for all of those around you. It's not going to be a good deal. Understand? Right. I've amended your conditions. So the first step is let's get this substance abuse evaluation with Mr. Jakes and do your counseling and things with him and listen to what he says and learn. So you do what you're supposed to do. Okay. All right, come over here and see officer what your Mr. Perry. All right, this is on the record, CR 2273. Mr. Perry, you're set for arraignment today. I've spoken with Mr. White, has made himself available to the court. I've spoken to him. And so he's confirmed some of the things that you said. And also, there's some other things that that do not put us in a position to go forward with your arraignment today. So what I'm going to do is I'm going to reset you until May 24th. And that will be at 9 a.m. You'll meet with Mr. White next week. And then if Mr. White accepts the employment, then he can file a waiver of arraignment. He'll discuss that stuff with you later. If not, then I'll see you back on May 24th at 9 a.m. Deputy McLeish here is going to have this form. You'll sign it. We'll give you the yellow copy, and you will be free to go. Thank you, Mr. White. Appreciate you, sir. right, this is cause number CR 21358, State of Texas versus Gary and Hamner. Mr. Hamner, if you will raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Mr. Hamner, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Ms. Casey Chester. Can you tell me that you're pleased with her representation?
I'm sorry?
Can you tell me if you're pleased with her representation?
Yes.
Do you feel like you've had enough time to discuss your case with her and have all of your legal questions answered?
Yes.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No.
Ms. Chester, do you believe Mr. Hamner to be competent today?
I do, Your Honor.
And have you explained to him all of his legal rights?
Yes, sir.
And do you believe he understands them?
Yes, I do, Judge.
All right, Mr. Hamner, I see here that you are charged by indictment with a state jail felony offense of abandoning or endangering a child with criminal negligence. A state jail felony carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice State Jail Division, and an optional fine not to exceed $10,000. Do you understand that range of punishment?
Yes.
That means if you are ever subsequently convicted and sentenced by a court or by a jury, your sentence would have to fall somewhere within that range. You understand that?
Yes.
I also see here that the plea agreement that you've reached with the state is that you would plead guilty to that charge, and you would be requiring them to make a recommendation that your sentence be assessed at 18 months confinement in that state jail prison, with that sentence being suspended and you being placed on probation for a period of 3 years, along with a fine, court costs, and reimbursement fees. Is that your understanding of the plea agreement? So you understand that if I approve this today and assess your sentence, you're going to be convicted of that offense. Your sentence is already going to be assessed today. It'll be 18 months. And if you go on probation and you violate the terms and conditions of your probation, the court would conduct a hearing. And if the court finds by evidence that you violated one or more of those conditions, then the court could revoke your community supervision and impose that original sentence of 18 months.
Yes.
Understanding all of those things, do you still wish to go forward?
Yes.
All right, court will ask you at this time, Mr. Hamner, how do you plead to that charge?
Yes.
Are you pleading guilty because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty today? Court accepts the defendant's plea of guilt. Ms. Chester, any objection to the state's evidence?
No objection.
State's evidence is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Anything further from the defense?
Nothing further from the defense.
So did I admit state's evidence? Did I admit state's evidence? Okay. Okay. Thank you. Sorry. All right, the court has reviewed the evidence. I do find sufficient evidence to convict Mr. Hamner of this offense. The court will follow the plea agreement in this case. The court hereby convicts Mr. Gary Hamner of abandoning or endangering a child with criminal negligence. The court will assess his punishment at 18 months confinement in the State Jail Division of TDC. The court will suspend that sentence today, place him on community supervision for 3 years, order him to pay a $1,500 fine, $290 court cost, $540 reimbursement fees. All right, Mr. Hamner, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with Deputy McLeish, and then after that time, you'll report over here to Officer Richard. So you can go ahead and step forward at this time. Houston Carpenter. Mr. Carpenter, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Your name is Houston Scott Carpenter, is that right? Mr. Carpenter, are you a United States citizen? Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're also represented by your attorney, Miss Casey Chester. Are you pleased with her representation of you?
Yes, sir.
Like you've had enough time to discuss your case with her and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No, sir.
Chester, do you believe your client to be competent today?
I do, Your Honor.
And you've explained to him his legal rights?
I have.
You believe he understands them?
Yes, Judge.
Mr. Carpenter, I see here that you are charged by indictment with forgery of a financial instrument and that you are also wanting to enter a plea agreement in that case under section 1244A, which would mean that you would be, upon your plea of guilt, you would be convicted as a felon under that offense, and your punishment would be assessed at 66 days confinement in the county jail. You would receive credit for all 66 days of time already served. You would be ordered to pay a $1,000 fine, restitution in the amount of $309.68, plus court costs and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
And State, is there any concern about collection of restitution in this matter if Mr. Carpenter decides not to pay? I'm not sure. I'm assuming the restitution is to the owner of the financial instrument that was forged, or the bank or something.
That's correct. It says victim on the judgment.
Mr. Carpenter, when do you anticipate you will pay the $309.68 restitution owed to Eddie Lee?
I have to make payments on it. I live on disability.
So how long do you think it'll take for you to pay that out?
About 2 months.
2 months? All right, Mr. Carpenter, understanding the plea agreement, understanding the range of punishment, at this time I want to ask you, how do you plead to forgery of a financial instrument? Are you pleading guilty of that crime because you are guilty of committing that crime?
Yes.
Did anyone threaten, force, or pressure you to plead guilty today?
No.
All right, the court accepts the defendant's plea of guilt. Ms. Chester, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your
From the defense?
No, Your Honor, sorry.
All right, the court has reviewed the evidence. I find that there is sufficient evidence to convict Mr. Carpenter of this offense. The court will follow the plea agreement between the defendant and the state. Court hereby convicts Mr. Carpenter of that offense, assesses his punishment under section 1244A of the Texas Penal Code at 66 days confinement in the county jail. The court awards him 66 days credit for time already served. Orders Mr. Carpenter to pay a $1,000 fine, $309.68 in restitution, $290 court cost, and orders him to reimburse Van Zandt County in the amount of $590. Mr. Carpenter, so this is a lot of money that you owe. So when you leave here, I want you to go down to the end of the hallway and I want you to meet with the court collection compliance officer, Ms. LaPrade, and you need to talk to her about setting up a financial plan so that you can pay Van Zandt County what you owe them in addition to what you're going to have to pay the victim in this case. Your failure to pay on that payment plan is going to result in this court issuing a warrant for your arrest. We're going to come right back here. We're going to do this again. Understand? So let's not do that. All right, Mr. Carpenter, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted. After that time, I want you to get a copy of this and go down and see Ms. LaPrade at the end of the hallway on your left. Ms. Chester, I'm sorry, I'm going to have to bump you out of line for a second.
That's okay.
I have an interpreter who is scheduled online, Mr. Manning, and then I'll get you right back in. I can hear you now, yes. Yes, ma'am, please.
Sí, buenos días.
Sí, de acuerdo.
Great, thank you, ma'am. All right, this is cause number CR 21290 and CR 21316, State of Texas versus Jose Guadalupe Herrera. We are set for docket call today, and the court is providing a Spanish interpreter for Mr. Herrera. So at this time, I'm going to ask you, Ms. Villiers, to raise your right hand. I'm going to place you under oath.
No puedo levantar la derecha porque no. Oh, oh no. Okay. Okay.
Thank you, ma'am. All right, ma'am. Do you swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment? So help you God. Thank you, ma'am. All right, Mr. Manning, we are set for a docket call today. Any announcements on the case?
Yes, Judge, the state and immigration agreement, as of our last setting, we requested that we give an additional time for my clients to speak to an immigration attorney regarding the consequences of the plea to the office of the plea to Judge. I admonished my client both in writing and verbally at court as well as sentence that he can do so. At this time, he's been unable to do so. We are going to express something set for plea next available setting so that we can take.
Okay, Mr. Manning, will you come up here to the podium, and that way we get the microphone here, because I'm not sure. That's pointing at him. All right. Yes, Mr. Manning, if you could restate.
Absolutely, Judge. We were originally set last time for pretrial, requested additional time for Mr. Herrera to consult with an immigration attorney regarding the impact of a plea on his status here in the United States. I advised him both in writing and verbally at the time of our last setting and since, but he has been unable to meet with an immigration attorney. However, after speaking to him today, he does want to go forward with the state's plea, and we would request we set for a plea at the next available setting.
Do you know when you're going to be back here next?
Okay. Judge, it looks like I am set May 12th.
That works for me if it works for you.
As well as
I think May 12th. May 12th is good.
Okay.
And is this plea for time or probation?
it is a plea for time.
Plea for time.
Time served.
Time served. So it doesn't require to be at the jail.
No, it doesn't.
So it can be an AM plea.
Yes, Judge.
Ms. Villiers, can you determine if there's any availability for you or anyone else at OCA to attend a plea hearing for Mr. Herrera on May 12th in the morning, anytime between 9 and 12? No, ma'am. Whatever's convenient for you. Thank you, ma'am. They are available? Okay. Do you have any other conflicts, Mr. Manning, that you need to,
No, Judge, I'm here in the morning and available all day.
do you know how many settings you have?
I just believe I have one besides Mr. Herrera.
Let's set it then earlier. Let's set it at 10 a.m. That way you're not waiting until late. Uh, 30 minutes should be fine. No, ma'am, you all do great, so I'll let you fight amongst yourselves. Thank you. All right, and if you'll just tell Mr. Herrera that Mr. Manning's going to have him sign a reset form with that new date and time, and then afterwards, he will be free to go. And actually, and Ms. Villiers, I'm going to actually need your assistance for one more thing that we need to discuss before he goes. All right, and Mr. Manning, I failed to mention, so in anticipation of the plea on that May 12th date, I show here that Mr. Herrera is delinquent $300 on between his bond supervision and his attorney fees. So I would really love to have all of that resolved before we do the plea. And definitely, definitely if it's going to be time served and he's going to walk away, I would really like to have that resolved before the plea.
Judge, and I'll motion for Mr. Herrera suffered a stroke and had rehabilitation.
So is that microphone on right there? Is it on green? Will you just name it towards you?
Mr. Herrera suffered a stroke, and his rehabilitation, while it has progressed, it's still been slow, and he has been unable to work in his current condition. He has no use of his right side of his body and is only able to walk with a brace. He is not able to use his right hand or do anything else. And so he has, on top of being qualified as indigent, has been unable to work since the time of his stroke.
Okay, and so and Ms. Interpreter, if you'll just admonish Mr. Herrera that I want him to make every effort to resolve the financial obligations that he owes before May 12th. And I do understand what Mr. Manning has said regarding his physical health. I do take that into consideration, but any effort that he can make to resolve the financial obligations would be appreciated by the board.
Okay, thank you.
All right, and he is free to go. Yes, ma'am. Thank you very much. I appreciate your help today. Thank you. All right, Ms. Chester, where do you want to go on next?
Whichever one the court wants.
We've done all your pleas, right?
Yes, Judge.
All right, we'll just go down the list.
Okay.
So we did Houston Carpenter. Jackie Elliott's not here, correct?
Jackie, that is correct. She called, it's my understanding that she also called probation this morning, or her check-in. And she called me, she recently started working, I don't know if the court is aware, but, she recently started a new job and they had an event that she had to be at, otherwise they were going to replace her. That's what she told me, they were gonna find somebody else. So she asked, you know, what to do. So I told her that I would let the court know. I was hoping to be here by the time roll was announced, but I was not. So we would just ask for a reset on that and not to forfeit her bond. She's just working at the moment. And she said that she would make sure that she'd be here at whatever reset date the court has.
I just spoke to her. She's almost here.
Oh.
Because of bail bonds.
Okay, all right, well, I'll just recall her case
Within the next 10 minutes.
Okay, good, thank you. All right, we'll move on. Chase Enochs. All right, so CR 21-324, Mr. Enochs is set for docket call.
That's correct, Judge. We've spoken with the state. There's some additional evidence that I've gotten from Mr. Enochs that I need to tender over to the state. We were making sure that everything was good in order to be sent over. And then I actually got some more information this morning that I'm going to give to the state. So we're just asking for one more docket call and hopefully we can get something resolved in negotiations.
No objection to the state, that is our understanding. It's just let me know that their information will back to the value. Offer a different offer.
You available on either May 12th or May 24th?
May 24th, yes.
All right, court will set Mr. Enochs for a final docket call on May 24th at 9 a.m. Once you sign, you get the yellow copy, you're free to go. Christopher Nash. This is CR 21-388, separate docket call.
Yes, Judge, this is, we're asking for one more docket call setting. This is actually on me. I picked up the disc discovery. We had the written discovery and I just didn't have the disc discovery. And I have just been out of my office and unavailable to have Mr. Nash come in and be able to view what he would like to view on it. So I've spoken with him and we'll get a time where he can come in and view those videos.
Your objection from state. Mr. Nash, I show that you're delinquent on your bond supervision and your attorney fees. Why is that? So you're gonna pay $310 by next week? All right, I'm gonna reset it, and then if you're not caught up by next week, then we're gonna talk about that at the next setting. I'll do the talking, you'll do the listening, the next setting, okay? All right, court's gonna reset Mr. Nash. Did you put that same date, Ms. Jester?
Yes.
May 24th? Yes, make sure you get that taken care of. John Piercefield. Mr. Piercefield, what do you got going on back there? Not good. Broke your leg? Which bone? Yeah, you going to have surgery or anything? When did that happen? 2 weeks ago. Goodness. I guess all in all, he said 15 feet. All in all, still pretty lucky. It's just a tibia. which is easy for me to say because my tibia is not broken. So when I say just the tibia, I know that's very painful. All right, this is cause number CR 2275. Mr. Piercefield set for arraignment.
That's correct, Judge. We've gone over the indictment. He understands the charge that is being alleged against him. He stated that his name is spelled correctly, and at this time, we would waive formal arraignment, enter a plea of not guilty, and ask to be set for pretrial docket.
All right, court will find Mr. Piercefield has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record, and the court will set this for pretrial hearing on May 24th at 9 a.m. So Mr. Piercefield, once you sign this form with Ms. Chester, she's going to give you the yellow copy that's going to have your date and time on it. I need you to make your way up here. There's going to be conditions of pretrial release that you have to sign, that you have to comply with. These are going to be things that say that, you know, you can't be using controlled substances or alcohol. You can't be getting arrested for new offenses. There's going to be other conditions. You're going to have to comply with all of those. If you fail to, then I can revoke your bail in this case and put you back in jail. Okay. So I'll need you to come up and fill up that paperwork. And then there's one more person I want you to see, and I don't know if you'll catch her before she goes to lunch, but I show that you have an older case that you owe money on. Back in like 2014, 15, somewhere around there. It shows that you owe $882. I know the cause number. I don't know much about the case, but that individual is at the end of this hallway on the left, Mr. Brad. And basically what we need to do is make sure that you're on some kind of payment plan. Not asking you to pay it all up front or pay half, but then you try to make some kind of monthly payment towards it. I understand that you're not working right now. We'll take all that into consideration, but we need to get going on that. Otherwise, what will happen is later she'll bring you a request for a warrant for you not paying. Okay. So two things: come up here and meet with the pretrial release department, and I'll ask Ms. LaPratt to stay a little bit longer to make sure that she meets with you. Meet with them, and then run down the hall as fast as you can and meet with Ms. LaPratt. Okay. Oh, you've already met. Oh, I'm sorry. Okay. All right. So they said you've already taken care of that paperwork. I'm sorry. Go out. Hit the hall, hang it right, and then down on your left. I'll tell her that you're on your way. Okay. Search. 37. Mr. Piercefield. Okay. You're good. Well, let me take over for a second. We'll get you on anyway, okay? This is cause number CR 21-323, State versus Jackie Lynn Elliott. We're set for docket call today. Ms. Chester, go ahead.
Yes, and what Ms. Elliott said was true, just like we made our original announcement. That original announcement won't change. We're just asking for that additional docket call. We weren't expecting Ms. Elliott to be here, but we expect to either have a plea agreement worked out and ready to plea at the next setting, or at least let the court know something else.
Any objection from the state? All right, court will reset Ms. Elliott for docket call May 24th. The date of?
That's the other ones, yes, at 9.
Yes. At 9 a.m.
Does the court have any schedulings that are on like Thursday, some of the new Tuesday like since that she has slated, a lot of events coming up?
I got May 12th. That's a Thursday. That's week after next. Would you rather do that?
Yes, please.
All right, so Miss Elliott, this is what we're gonna do. There's your yellow copy. Because you are late, it's my policy that what you're charged with and you're late, I'm gonna UA you, okay? So if you're violation of anything, I'm gonna keep you, just so that you know. So come on back here and meet the officers, give you UA. You're negative, you're free to go. You're positive, you're gonna stay with me. Okay? Did she come back through and say that she called the names? There was no response. I don't remember. Call the names. Did you call the names Ashley Duran and Otis Wheeler loudly 3 times in the courthouse?
I did, Your Honor.
Was there any response to those names?
There was no response, Your Honor.
Shocking. Shocking. But we have had responses before.
Well, probably that's downstairs.
All right, the court has called CR 21-354, State versus Ashley Renee Duran. State is all, or the court is also called Otis Daryl Wheeler. Cause number CR 2281. names, they were called at 9 a.m. They were not present in the courtroom. They're not present in the courtroom at this time. And the bailiff has called their names loudly, distinctly 3 times in the courthouse with no response. As a result, the court will issue judgment nice eyes, find their bonds to be forfeited, and will issue capias for their arrests. And we will stand in recess until 1:30, and we will resume with the jail.